My name is Todd Bigelow. I'm a freelance photographer for the past 30 years based in Los Angeles, the founder of the Business of Photography Workshop, an adjunct professor of photography and photojournalism, and the author of a book on freelance business practices. This is a short video series where I address business practices that freelancers should be aware of. Hope you enjoy. Hey everyone, thank you for stopping back by. If you're dropping by for the first time, I appreciate your interest in freelance business practices. Today I want to talk about a topic that really impacts a lot of photojournalists and photographers outside of photojournalism, and that's infringement. The unauthorized use of our work is a problem that just became a wildfire in the last 10 to 15 years. Obviously with the explosion of digital publishing. It's something that results in, financial loss to photographers, but also impacts, my personal concern with having images used in ways that I would not, license them for use for. So I want to control how my work is used. And I count on the copyright law, which specifically gives me those rights as the intellectual property owner to control how and where, my images are used. So let's talk a bit about what I've done to protect my work for many years now. So there's kind of 5 bullet points to just make this very simple, right? To kind of give the basic foundations, which is what this whole short video series is about. If you need additional information on the basics of copyright and registering, there are some other videos in this playlist that you should go and look at, okay? But for now, I want to talk about 5 bullet points for dealing with infringement. The first is retain, the second is register, the third is monitor, the fourth is protect, and the fifth is combat. So let's look at these just real quickly individually. Retain the rights to your work. You have to retain the rights to your work. There's nothing more simple. It starts with that process. If you sign away the rights to your work in a work for hire agreement, you are no longer the sole copyright owner, which is often what a settlement agreement will require that you acknowledge. And I just had one from the past several days where that clause was very specifically stated, and I had to, obviously acknowledge that that was the case. So if you're signing joint copyright agreements, which are often, offered by major publishers, be aware of that fact. But you need to retain the copyright to your work. So retaining the copyright is obviously proving that you are the owner of the work and therefore have the legal right to, protect it and initiate any sort of infringement proceeding. Okay, so retain the rights to your work and don't sign those away in work for hire contracts. Register your work. So registering your work with the United States Copyright Office is mandated if you're going to file a lawsuit. So if you file a lawsuit, if you hire a lawyer and they file a lawsuit in court, federal court, in order to usually just get the infringing party to respond, because oftentimes they don't, then the image has to be registered. I'm not saying the image is not copyrighted unless you register it. An image is copyrighted when it's created into a fixed, tangible, viewable form. I understand that, but there are levels to copyright protection, and if you really want the maximum protection, you need to register your work. That obviously opens up the opportunity for you as a copyright holder to pursue statutory damages, ask for the infringing party, if we prevail, if the copyright holder prevails, to pay for your lawyer's fees. Now, none of those things are 100% guaranteed, of course, but registering your work not only is mandated to file a lawsuit, it actually helps even if you don't file a lawsuit, and you can prove to the infringing party, that the image is properly registered, that you are the copyright holder. That serves as an impetus for them to step forward and resolve the matter, because they know that it can get perhaps rather expensive for them to fight it and lose. Okay, so registering your work is mandated to file a lawsuit, but is also very helpful even if you don't file the lawsuit. It gets them to the table to listen. Monitor your work. So what do I mean by monitoring your work? Monitor your work on the internet. So I usually take several days, at least once a quarter, so a few times a year, where I take certain images and I do reverse Google image searches, or I right click and save from my archive and select, search Google for this image. I also search other search engines like Bing, because I found certain images showing up there that I don't find showing up on Google. And I monitor where those images are. Now, my work is pretty tightly held, so I license directly. I'm a contributor to Contact Press Images, so they have rights to go ahead and license that work as well. But it's very tightly controlled. So when I find images out there, I can usually determine pretty quickly that those images were not licensed properly. Okay, because my images are not widely distributed through Alamy and Shutterstock and Getty and so forth and so on. Okay, so I monitor by using the image itself. So Google will search the internet for using the binary data. So it'll search for any images that look similar to mine. Now, most of you have probably done the same and you know what I'm talking about. So I don't only rely on putting in keywords or, searching for my name, because that metadata is often stripped when images are uploaded. Okay, so take the time and monitor your work. If you do find that your images are being used without your permission, screenshot everything. Okay, including the URL, screenshot, create a folder, do all that before any sort of outreach is made to the offending or allegedly offending party. Okay. If you do engage with wide distribution of your work through a mega agency or wire service, please be very careful if you engage with that supposedly unauthorized user, because you want to make sure that they, did not acquire a license legally if you're going to contact them and use any sort of which I definitely don't recommend, any sort of threatening language when you contact them, okay? So protecting your work. So when I protect my work, what do I mean? I try to take advantage of the tools that are available to me, especially on my website. I use a photo shelter-based site. There is an option for you to check a box where it disables right-click and save. Okay, so you cannot right-click and save an image from my website. I also downloaded a plugin for my WordPress blog, which does the same thing, so that images that are posted on the blog cannot be right-clicked and saved. I recognize that there are ways around all of these things, okay? People can screenshot. I do not use a watermark across every image on my website because I find it very aesthetically unappealing. Okay, I don't want to build this massive wall against infringement where it really makes engaging with my work, not a nice process. So I try to find that middle ground where I protect my work by, disabling right-click and save. I protect my work by definitely watermarking images that go out on social media, things of that nature. And I protect my work by retaining my rights and keeping close control of who can license that work. Okay, so that part is very important to the process, excuse me. So the very last step, combating infringement, is oftentimes, what most of us are talking about out there. But, you have to have those other four things in place, I believe, in order to really properly combat infringement. So how do I combat it? Well, if I find that images are being used, oftentimes I will personally reach out to the, infringing party, and I engage in absolutely the most courteous, professional, communication that I'm capable of. So there is no threatening language. There's no threats of lawsuits or, no demands made. I simply ask if they have the rights or have acquired a license to use the images. I obviously already have the screenshots, so I will include those when I send them. But again, it's very non-threatening behavior. I go more into this in my workshop. I actually show some of the emails and so forth that I send. I'm not going to do that right now, but what I do want to make clear is that it's a very professional process, and I give them the opportunity to request a retroactive license if they'd like to go ahead and kind of resolve this situation. Again, with no, legal, involvement, no lawyers involved or anything. I, allow them to request a retroactive license, and I will go ahead and license that image to them, but then demand, obviously, that license ends right there. Okay, that's some of the time. That's some ways in which I deal with the infringement. The other way is if I do reach out and I get no response, or I get a go pound sand type of response, then I engage a lawyer, and I work with several different lawyers. And I will go ahead and forward all of the information, including when my registration was, when I see if I can come up with a date for when the infringement occurred. A lot of times there's a date posted on a publication for when it was published. I'll put all the screenshots together, so all the information is provided to an attorney, and then they can make the decision on whether or not they wish to go forward. Usually what they'll do is they'll reach out as well without filing a lawsuit right away to see if there is a way to go ahead and start a quick settlement process. If that's not the case, or it's better, the choice is made to go ahead and file immediately a lawsuit and then therefore serve them with the lawsuit, then that's the lawyer's advice. And if they advise that, then I typically go ahead and follow their advice, of course. And then it will begin the proceeding of hopefully their lawyer engages with my lawyer, and we come up with a settlement. And that's usually what happens, quite frankly. But you have to be prepared to go forward, and I am. I'm prepared to value my images, come up with a valuation. I have all of the registration done properly. I can prove that they did not license. I can prove that I have, can value that image again, going back to valuing. Usually my images have been licensed before, those that have been stolen. And that's oftentimes, I think, where they find them on other websites that have legally licensed. So I'm prepared to go forward and through and into the discovery process, but that's not usually what happens. Usually a settlement, can come to fruition. So, but I'm prepared to go forward because I don't want to engage the process and then, I'm not prepared to actually see it through to the end. It's important that I combat infringement because my work and where it's used is very important to me. The subjects that are in it are important to me. So I think it's, necessary for me to use the U.S. copyright law so it doesn't become toothless. And go ahead and protect my work to the full extent of the law. Okay, so I retain the rights, I register, I monitor, I protect, and I combat. All right, so that's basically the foundation for how I deal with infringement. All right, I hope it helps. Thanks for stopping by. Go ahead and take a look at some of the other videos. You might find some other information helpful as well. And I'll see you again.